In the foreseeable future, the conviction of Lucy Letby will end up at the Court of Appeal. This is indeed the only feasible method and certainly the only immediately accessible way of overturning her wrongful conviction. In this video, I'm going to examine what will happen at the Court of Appeal. Part 1. The Judicial Process. In England and Wales, a criminal appeal from the Crown Court goes to the Court of Appeal Criminal Division, normally sitting at the Royal Courts of Justice in London. The important point is that the Court of Appeal does not conduct a second trial. There is no new jury assembled. Its central task in an appeal against conviction is to decide whether the conviction is unsafe. Under Section 2 of the Criminal Appeal Act 1968, if the court thinks the conviction is unsafe, it must allow the appeal, otherwise it must dismiss it. Usually for an appeal, after a conviction, the defendant's lawyers identify particular grounds of appeal. These are not simply arguments that the jury reached the wrong conclusion, they instead identify some reason why the conviction may be unsafe. In Lucy's case, because the Criminal Cases Review Commission, often abbreviated as CCRC, has presided over the case and will refer the case, its statement of reasons becomes extremely important. When the CCRC refers a case, it provides a formal statement of reasons explaining why it has made this referral. CPS guidance state that the CCRC supplies this statement to the parties and that the material on which the CCRC relied is passed to the prosecution for the purposes of the appeal. Similarly, if the Criminal Cases Review Commission refers a conviction to the Court of Appeal, the convicted person does not have to persuade a single judge to grant leave. A CCRC reference is one of the express exceptions to the requirement for leave. Once the CCRC makes the reference, the Court of Appeal process begins and the appellant's lawyers formally lodge grounds explaining the case they intend to advance and how those grounds relate to the CCRC's reasons for referring it. A CCRC reference does not give the appellant an unlimited right to argue absolutely anything that they want. Section 14 of the Criminal Appeal Act 1995 distinguishes between grounds which are related to the reasons given by the CCRC for making the referral and completely separate grounds. The referred appeal can proceed on grounds related to the CCRC's reasons without obtaining leave. But if the appellant wants to add a ground unrelated to any reason given by the CCRC, the Court of Appeal must give permission for that additional ground to be pursued. Now, what is very likely to happen in Lucy's case is that after the CCRC makes a referral on whatever grounds the case is referred, and there are many possible, the defence will argue that the court must hear everything that they have to provide from all of the 33 experts that are affiliated with the defence and will presumably have been instructed. It may not be 33 experts because there could have been more experts recruited by that time, but all of the experts that have been recruited will be involved. I should explain briefly that to be instructed means that a lawyer legal team or sometimes another authorised party has formally engaged a specialist to provide expert evidence in a legal case. Typically, the expert will receive a letter of instruction setting out the background to the case, the documents or evidence they should examine, and the specific questions on which their expert opinion is sought. They may then review medical records, scientific evidence, photographs, reports, witness statements, or other relevant material, and in the process prepare an expert report. Then the prosecution responds. The prosecution will be notified and may be directed to lodge a respondent's notice and or skeleton argument. The prosecution will set out why it claims that the conviction remains safe and respond to the particular grounds advanced by the appellant. It must be added that it's not absolutely inevitable that the prosecution will do this. I certainly expect that they will do this in Lucy's case, but they don't have to claim that the conviction is safe. They can say, we now believe that the conviction is unsafe. Before the hearing takes place, it's therefore usual for there to be a considerable exchange of material, and that will definitely occur in the Lucy Letby case. Part 2, the appeal hearing. The Court of Appeal can, at this point, receive evidence that was never heard by the jury. Under Section 23 of the Criminal Appeal Act 1968, an appellant who wishes to rely on fresh evidence must make a specific application to have it admitted. The court considers matters including the credibility of the evidence, its relevance to the appeal, and why it was not produced at trial. For example, several new medical experts, which obviously applies in this case, conclude that the prosecution's original medical mechanism was wrong. Their reports can be submitted to the court. That does not automatically mean that all of those experts will appear in court. The evidence may be dealt with through written reports, or the court can decide that it needs to hear from the witnesses themselves. Only the full court can formally receive this fresh evidence. Experts and other witnesses, though, can give evidence if required. Where the court decides oral evidence is necessary, the hearing can begin to somewhat resemble a Crown Court trial, obviously without a jury. An expert can take an oath of affirmation, give evidence, be questioned by the appellant's barrister, be cross-examined by the prosecution, and be questioned directly by the Court of Appeal judges. Indeed, judges are often particularly active in questioning witnesses because they are themselves the decision makers. There is no jury for counsel to persuade separately. The March 2026 Court of Appeal guidance expressly provides for witnesses connected with fresh evidence applications to attend and give evidence where the court considers that necessary. The substantive appeal will normally be heard by a panel of senior judges, commonly 3 judges, although the Constitution can vary according to the importance and nature of the case. The appellant's barrister will usually open the case, and then a simplified process for the hearing might go as follows. The appellant's counsel will speak. They will explain why the conviction is unsafe. The judges will question the counsel. Fresh evidence and experts will be introduced. Then the prosecution counsel will speak. They will explain why the conviction remains safe. The judges will question the prosecution counsel, and the appellant may reply. Of course, the process can become very much more complex than that, but that is a basic outline of something that may occur. The Court of Appeal is based at the Royal Courts of Justice, and cases are heard by Lords Justice of Appeal, and in certain cases, High Court judges. I'm not really sure what will apply in Lucy's case. That remains to be seen. It is worth mentioning at this point that the media can report Court of Appeal proceedings on a day-by-day basis while the hearing is taking place. There is no general rule requiring journalists to wait until the appeal is finished or judgment has been delivered. That follows from the principle of open justice. Section 4(1) of the Contempt of Court Act 1981 specifically protects a fair, accurate and contemporaneous report of legal proceedings held in public. Now, what I will say is that when the Colin Norris/Colin Campbell case was taking place, I don't recall seeing any reporting at all, but I would find that extremely unlikely to occur in this case, given the enormous public interest and enormous media interest. I expect there will be daily reporting. Similarly, as far as I understand it, it's absolutely permitted for me to post a daily report on the Court of Appeal process. I will probably do this rather than attending the Court of Appeal to try and keep viewers informed rather than going to the Court of Appeal myself. I'll obviously consider that nearer the time, but I know you can get audio access and visual access online, so I will probably watch that, make notes, and then submit a report in the evening after each day's proceedings have concluded. It may be necessary for me to disable the comments section during this process. In fact, it's very likely that I'll do that. Part 3, the verdict. So the crucial question at this point is simply, is the conviction unsafe? This is where Court of Appeal proceedings will differ substantially from a trial. The judges are not asked, would we have convicted this defendant, nor are they conducting a completely new trial. The statutory question is just, is the conviction unsafe? That means the court has to assess the significance of whatever has gone wrong or whatever new evidence has emerged. For example, if there was expert evidence that has now collapsed, which of course applies to this case, then the question would become, taking the trial evidence, the new evidence, and the defect that has been demonstrated together, can this conviction still safely stand? That can require the court to look at the case as a whole rather than considering an individual error in isolation. The judges can also reserve judgment. The court does not necessarily announce its decision at the end of the hearing. In an important or complicated case, the judges may say that they are reserving judgment. They then deliberate and prepare a detailed written judgment, which may be handed down weeks or sometimes considerably later. The court's current guidance specifically deals with the procedure for circulating and handing down reserved judgments. There are essentially three important outcomes. For an appeal against conviction, the principal possibilities are appeal dismissed, the judges conclude that the conviction is safe and the conviction stands; appeal allowed and conviction quashed, the court concludes that the conviction is unsafe and the conviction is quashed, the person is automatically released; and appeal allowed, conviction quashed, and retrial ordered. The court concludes that the original conviction cannot stand, but considers that justice requires the defendant to be tried again before a new jury. The Criminal Appeal Act gives the court the power to order a retrial after allowing an appeal. That distinction is important because winning an appeal does not necessarily mean that the proceedings are over. If a retrial is ordered, then the case goes back to the Crown Court. It then becomes a new criminal trial with a new jury, prosecution evidence and defence evidence. The Court of Appeal naturally does not decide guilt at that retrial. The present Court of Appeal guidance states that following a retrial order, the Crown Court must comply with the directions given by the Court of Appeal. It also reflects the statutory timetable requiring arraignment normally within 2 months of the retrial order. At this point, the Crown Prosecution Service would also have to keep the case under review and determine whether it continued to satisfy the full code test. Although the Court of Appeal had ordered a retrial, the CPS would not be obliged to pursue the case regardless of the evidential position. It could ultimately decide not to proceed, for example if there was no longer a realistic prospect of conviction, in which case it could offer no evidence at the Crown Court. I believe that this is an extremely likely scenario if a retrial is ordered. And I'll finally just mention this case is very unlikely to go to the Supreme Court, as they only rule over procedural issues. Part 4. What will happen in Lucy's case? So in this section I'm going to tell you what I think will happen at the Court of Appeal. Now this is just my opinion, but I've spoken to a lot of people about this and I've studied previous cases and I think I understand how the law works. I'm certainly not an expert, but obviously I do know this case inside out, and I think what I'm going to tell you is very likely to be at the very least close to what occurs in the Court of Appeal. So the first thing is the prosecution will proceed on narrow legal terms. Stephen Phelps, who's been a guest on this channel, always tells me this is a court of law, not a court of justice. So they won't call experts. It's very unlikely that the prosecution will call any experts, and I'll go through the reasons for this. Firstly, it's difficult for them to get new experts for obvious reasons. No one wants to be associated with this because it's an absolute debacle. Evans has been completely discredited at this point and would be a total liability. Bohin is in pretty much the same boat, plus she's associated with the latest failed cases where she was the expert. She also conceded to the Daily Mail that she read all of Dewey's reports and conclusions before doing her so-called peer review. Hindmarsh is perhaps not as discredited, but the situation doesn't look great for him based on what's been in The Guardian, and he would have to defend the sticky insulin theory, which is total rubbish. And then Arthur's provided evidence which doesn't support the prosecution case, and the other experts basically did nothing. In particular, the prosecution, though, won't attempt to defend the evidence of Evans or his theories. In fact, they will deflect as much attention away from that as possible. What they will try to do is claim that the conviction is safe. They will make procedural arguments. They will argue that what the defence is providing does not constitute new evidence. They will claim that the defence is attempting to relitigate the trial, and they will try to pick holes in some of the claims made by the defence. It is also not impossible that they will try to get endocrinologists to say that the insulin readings are sound. I doubt they will make any other strong statements regarding any of the other science that was in the individual case, because their position will be, firstly, it's the job of the defence to unpick this, not us to defend what we've done, and also they won't want to bring the science in because that will actually weaken their case, not strengthen it. The prosecution case, they will not go in there and attempt to defend the prosecution case because it's indefensible, A, and if they try to do that, they'll literally shoot themselves in the foot. B, their best chance of winning is to convince the court that the appeal is procedurally unfounded. And C, legal people at this level are obsessed with the law, and as mentioned, let me reiterate, this is a court of law, not a court of justice. Now, the Court of Appeal has the power to require witnesses to attend, including witnesses who gave evidence at the original trial. Section 23 of the Criminal Appeal Act 1968 expressly allows the court to order any witness to attend and be examined whether or not that witness was called in the proceedings below. So the defence could ask the Court of Appeal to have Dr. Dewi Evans give oral evidence and then cross-examine him, but the judges would decide whether that was necessary for resolving the appeal. I would suggest, in a bizarre twist, that the prosecution will fight against that, and the prosecution will not want Dr. Dewi Evans to appear at the Court of Appeal. However, what the defence will have to argue is that the standard of evidence was so poor in the original trial that the fresh evidence and all the new evidence and all the new reports and everything else must be considered admissible by the court, particularly when combined with the fresh evidence that clearly exists. This is a matter of natural justice, and they could also argue that the consequences outside of the court are so significant for what are important areas of British society that a more transparent process than occurred in the original court case and a more satisfactory process must be allowed to happen. They can also make capital out of disclosure, police issues, and of course J-Ram's potential perjury. And that is essentially what will happen at the Court of Appeal. There will be minimal effort, if any, made by the prosecution to defend the science used in the original trial. They will rely on procedural arguments and attacking the defence. They are also extremely unlikely to call, for example, Evans, because they will recognise that he's more toxic to their case than Chernobyl. The decision will ultimately come down to the dichotomy between reason, science and truth on the one side and policy, procedure and law on the other side. And I couldn't even begin to tell you what will ultimately happen, but I can say this. If the Court of Appeal tries to hide behind legal arguments, what can be called arguments of jurisprudence, and essentially states, you could have said this 3 years ago, which is what it often does, there will be an almighty shitstorm. The media will absolutely castigate them, so I hope they're ready for that.